Hi friends, welcome to my channel DSK Exam Prep. In this video, I am going to explain some important questions, around 80 plus important questions regarding the Supreme Court, that is the Union Judiciary. First question, which part of the Constitution deals with the Union Judiciary? The answer is Part 5. Part 5 of the Indian Constitution deals with the Union Judiciary, that is the Supreme Court. Next question. Part 5 of the Indian Constitution includes articles. The answer is 52 to 151. Just now we have seen Part 5 of the Indian Constitution deals with the Union Judiciary, that is Supreme Court. The articles in the Part 5 are from 52 to 151. Next question. The Constitution and jurisdiction of the Supreme Court are stated in detail in the articles. The Constitution and jurisdiction of the Supreme Court are stated in the articles 124 to 147. Okay, part 5 actually contains 52 to 151 articles. Okay, in that 124 to 147 deals with the Union Judiciary. Okay, next question. The judges of the Supreme Court hold office till the age of the judges of the Supreme Court hold the office till the age of 65 years. Okay, next question. The Indian judiciary is headed by the Supreme Court of India. Next question. To become the judge of the Supreme Court, a person must be, that means the qualifications to become a judge of the Supreme Court are he must be a citizen of India and a judge of the High Court for at least 5 years. The person should be a judge of the High Court for at least 5 years or an advocate of a High Court for at least 10 years. Okay, to become the judge of the Supreme Court, he must be a citizen of India and he must be a judge of High Court for at least 5 years or an advocate of a High Court for at least 10 years. Next question. Who appoints the judges of the Indian Supreme Court? The answer is the President of India. The President of India, on the recommendation of the Chief Justice of India, appoints the judges of the Indian Supreme Court. Next question. The judge of Indian Supreme Court may write his resignation to. The judge of Indian Supreme Court may write his resignation to the President of India. Okay, the President appoints the judges of the Supreme Court and the resignation also to be submitted to the President of India. Next question. The judge of the Indian Supreme Court can be removed by the President. That means the President can remove the Indian Supreme Court judge only after an impeachment by the Parliament. Okay, an impeachment by the Parliament. Next question. Who is the guardian or ultimate protector of the fundamental rights in India? The answer is Supreme Court. Supreme Court is the guardian or ultimate protector of the fundamental rights in India. Next question. The Supreme Court in India is first established at. The Supreme Court in India is first established at Calcutta. Okay, in Calcutta, the Supreme Court of India was first established. Next question. Judicial review in the Indian Constitution is based on. Okay, the question is judicial review in Indian Constitution is based on. The answer is procedure established by law. Okay, the procedure established by law. The judicial review in the Indian Constitution is based on the procedure established by law. Okay, if it is in USA, it follows due process of law. Let us see the difference in the next question. The Supreme Court at Calcutta was established by which act? The Supreme Court in Calcutta was established by which act? We have already seen the Supreme Court was first established in Calcutta and the act supports this establishment is the Regulating Act of 1773. Okay, Regulating Act of 1773. Next question. The difference between the procedure established by law and due process of law is. In one of the previous questions, we have seen for judicial review, the Supreme Court follows the procedure established by law in India. If it is in USA, they follow the due process of law. Let us see the difference. The procedure established by law checks for the law. Okay, that means if there is a law or not to deprive the life and personal liberty of a person. Okay, and the Supreme Court will follow that law. Okay, when it comes to the due process of law, it checks the Supreme Court checks for the law. That means if there is a law or not to deprive the life and personal liberty of the person. And also if the law is fair, just, or it is not arbitrary. Okay, the Supreme Court checks if the law is fair or not, and it is just or not, and it is not arbitrary or not. Okay, these two things will be checked by the Supreme Court. Let us see this again. See, the procedure established by law, that means it checks a law duly enacted is valid. A law duly enacted is valid even if it is contrary to the principles of justice and equality. That means the Supreme Court checks only for the law. Okay, if there is a law or not to deprive the life and personal liberty of a person. In procedure established by law, it is the main point. In due process of law, in due process of law, it not only checks if there is a law to deprive the life and personal liberty of a person, but also sees if the law made is fair, just, and not arbitrary. Okay. The law made is fair and just, and it is not arbitrary. Okay. First thing it checks if there is a law or not. Second thing, it is if the law is fair or not and just or not, and it should not be arbitrary in nature. Okay, the due process of law USA follows. Okay, the procedure established by law India follows. Okay, next question. The Supreme Court of India was first established on. The answer is 26th January 1950. The Supreme Court of India was established on 26th January 1950. However, the inaugural session was on 28th January 1950. Okay, next question. Who was the first Chief Justice of India? The answer is H.J. Kania. H.J. Kania. Harilal Jekisundas Kania became the first Chief Justice of India in 1950. In the previous question, we have seen the Supreme Court of India was established in 1950, January 26th. Okay, the first Chief Justice of India was H.J. Kania, Harilal Jekisundas Kania in 1950. Next question. Which article deals with the establishment and constitution of the Supreme Court? The answer is Article 124. Article 124 of India. Article 124 of India deals with the establishment and constitution of the Supreme Court. Next question. What is the sanctioned maximum strength? Sanctioned maximum strength of the Supreme Court judges, including CJI at present? The answer is 34. Okay, CJI and 33 other judges are sanctioned at present in the Supreme Court. So total number of 34 judges, the Chief Justice of India plus 33 other judges. Next question. What was the initial strength of the Supreme Court judges in 1950, including the Chief Justice of India? The answer is there were 8 judges including the Chief Justice of India. That means the Chief Justice of India and 7 other judges were sanctioned during the establishment of the Supreme Court in 1950. But now there are 34 judges, 33 other judges plus Chief Justice of India. Okay. Earlier it was 8, now it was 34. It is 34. Next question. When was the last time the strength of the Supreme Court of India increased? The answer is in 2019. Till 2019 there were 31 Supreme Court judges. Now there are 34 Supreme Court judges. Okay, in 2019 the number was increased. We have just seen there are 34 Supreme Court judges, Chief Justice of India plus 33 other judges. Okay, next question. In 2019 it was increased. The next question. Who has the power to change the strength of the Supreme Court of India? The answer is the Parliament of India. The Parliament of India has the power to change the strength of the Supreme Court of India. Next question. Under which article can the Supreme Court issue writs for the enforcement of the fundamental rights? The answer is Article number 32. Under Article 32, the Supreme Court of India can issue writs only for the enforcement of fundamental rights. Okay, the Supreme Court can issue writs only for the enforcement of the fundamental rights, and the article is 32. Next question. Advisory jurisdiction of the Supreme Court is provided under which article? The question is advisory jurisdiction of the Supreme Court is provided under article. The answer is 143. Under article 143, the advisory jurisdiction of the Supreme Court is provided. Okay, the president, what does it mean? The president can seek the advisory opinion from the Supreme Court on the matters of public importance. Okay, under article 143, the president can seek the advisory opinion from the Supreme Court on matters of the public importance. Next question. A constitution bench of the Supreme Court must consist at least how many judges? See, the question is about constitution bench. What does the constitution bench means? If there is any case related to the interpretation of the constitution, then there must be some number of judges to interpret this constitution. The answer is 5. The answer is 5. That means whenever there is a need to interpret the constitution, the at least 5 members of the Supreme Court judges should be there in the constitution bench. The next question. Who was the first woman Chief Justice of the India? The answer is Fatima Bibi. Fatima Bibi was the first woman Chief Justice of the India, and she was appointed in 1989 October 6. October 6, 1989, Fatima Bibi was the first woman Chief Justice of the India. Next question. The salaries of the judges of the Indian Supreme Court are determined by. The answer is the Parliament of the India. The Parliament of India will decide the salaries of the judges of the Indian Supreme Court. Next question. The judges of the Supreme Court after retirement are permitted to carry on practice or not? The question is about the retired judges of the Supreme Court. Can they practice after the retirement or not? The answer is no. They are not permitted to carry on the practice before any court. The next question. In which year the collegium system for appointment of judges was adopted by the Supreme Court of the India? See here, for the appointment of judges, the Supreme Court of India adopted a system that is named as collegium system. Okay, collegium system was for the appointment of the judges, and it was adopted by the Supreme Court of India in the year 1993. In the year 1993, for the appointment of the judges, the Supreme Court of India adopted a system which is known as the collegium system. Next question. The collegium system for the appointment of the judges adopted by the Supreme Court of India consists of how many number of judges? The answer is the Chief Justice of India and 4 senior judges. Okay. The collegium system for the appointment of the judges adopted by the Supreme Court of India in the year 1993. The collegium system consists the Chief Justice of India and 4 other senior judges. Next question. The Supreme Court of India has jurisdictions of how many types? The answer is 4 types. It is the original jurisdiction, the appellate jurisdiction, and review jurisdiction, and also the advisory jurisdiction. Okay, the Supreme Court of India has jurisdictions of 4 types. original, appellate, review jurisdiction and advisory jurisdiction. Next question. Which article of the Constitution permits the Supreme Court to review its own judgment? That means the review jurisdiction. The answer is Article 137. Under Article 137, the Supreme Court of India can review its own judgment. This is review jurisdiction. It is under Article 137. The next question. The curative petition in India can be filed in the Supreme Court under which article? The answer is under Article 142. Under Article 142, the curative petition can be filed in the Supreme Court. See, what is the curative petition? Curative petition is the last remedy after the review petition is dismissed. Suppose the Supreme Court has already given a judgment and then we file the review petition. Even if the review petition is also quashed or dismissed, then we go for the curative petition, and it is the last remedy after the review petition. Okay, it is under the Article 142. The curative petition in India can be filed in the Supreme Court. The next question. Judicial review implies. What does the judicial review means? The answer is the power of the judiciary to review upon the constitutionality of any law or an executive order. Okay, any law or any executive order can be reviewed by the judiciary to check the constitutionality of the law or executive order. This is the judicial review. The next question. Under which article the courts are prohibited from inquiring the proceedings of the parliament? See the question again. The courts are prohibited from inquiring the proceedings of the parliament. That means the parliamentary proceedings cannot be inquired by any court. Okay, but the question is asking about the article, under which article this is allowed. The answer is article number 122. Okay, under article number 122, the courts are prohibited from inquiring into the proceedings of the parliament. Under article 122. Next question. The president can seek the advice of the Supreme Court under which article? The answer is article number 143. Under article number 143, the president can seek the advice of the Supreme Court. Okay, this comes under the advisory jurisdiction of the Supreme Court. And see here, only if the president seeks the advice, then only the Supreme Court will give the advice, and it is not binding on the president to follow the advice of the Supreme Court. The next question. The Supreme Court is a court of record. What does this mean? The answer is all proceedings are formally documented and preserved as part of the public record. That is why the Supreme Court is called a court of record. Okay, it includes the initial filings, evidences and witness testimonies, and also the final judgments. Everything will be kept documented and preserved as part of the public record. That is why the Supreme Court is called the court of record. Next question. The proceedings of the Supreme Court and High Courts shall be in English. Under which article? The answer is Article 348. Under Article 348, the languages to be used in Supreme Court and High Courts shall be in English. Okay. Next question. The concept of public interest litigation is originated in which country? Public interest litigation means PIL, P-I-L. Okay. The PIL concept is originated in United States. The PIL concept, public interest litigation concept, is originated in United States, and a PIL can be filed in High Courts and Supreme Court. And also please remember, it is a judicial initiative. A PIL is a judicial initiative. Next question. What is Article 147 of the Indian Constitution? The answer is Article 147 deals with the interpretation of the Constitution. See here, Article 147 deals with the interpretation of substantial questions of law. Okay, if there is any substantial question of law, then the Supreme Court will interpret the Constitution based on the Article 147. Next question. What is Article 146 of the Indian Constitution? Article 146 deals with the staff and officers of the Supreme Court of India. and their appointment and administration is explained in the Article 146. The answer is Article 146 addresses the establishment, appointment and administration of the officers and staff of the Supreme Court. Next question. Who has the authority to appoint officers and staff of the Supreme Court under Article 146? The answer is the Chief Justice of India has the authority to appoint officers and staff of the Supreme Court, and it is under Article 146. Next question. How are the administrative expenses of the Supreme Court managed? The question is, how are the administrative expenses of the Supreme Court are managed? The answer is, the administrative expenses, that is salaries, allowances and pensions for the Supreme Court staff, they are charged from the Consolidated Fund of the India. Okay, the administrative expenses of the Supreme Court are charged to the Consolidated Fund of the India. Next question. What is Article 145 of the Indian Constitution? The answer is, it provides, Article 145 provides the framework for establishing rules of procedures for the courts in India. Okay, for the courts in India, it establishes the rules of procedures under Article 145 of the Indian Constitution. Who has the authority to make rules under Article 145? The answer is the Supreme Court and High Courts. The Supreme Court and High Courts both are having the authority to make rules under Article 145 of the Indian Constitution. Next question. What aspects do the rules under Article 145 covers? The answer is, who is permitted to practice before the court, and the procedures for hearing, and how the courts conduct its business. Okay, just now we have seen Article 145 covers the rules, establishment of the rules of procedures for the courts in India, and the points are, and it covers who is permitted to practice before the Supreme Court or High Courts or any court, and the procedures for hearing, and how the court conducts its business. All these things are covered under Article 145. Next question. What is Article 144 of the Indian Constitution? Article 144 says all the civil and judicial authorities in India, they must act in the aid of the Supreme Court to apply the orders and decisions of the Supreme Court. See here. Article 144 mandates. Article 144 mandates all the civil and judicial authorities in India, they must act in the aid of the Supreme Court. Why? For assisting in enforcing its orders and decisions of the Supreme Court. The next question. Why is Article 144 important? We have just now seen that Article 144 deals with the civil and judicial authorities to comply with the orders of the Supreme Court. Okay, that is why it is important. Let us see the answer again. See, Article 144 is important to ensure the smooth functioning of the judiciary by obligating the civil and judicial authorities to support the Supreme Court. Next question. Who is obligated to cooperate under the Article 144? The answer is all the civil and judicial authorities within the territory of India. Okay, all the civil and judicial authorities within the territory of India are obligated to cooperate under Article 144. Okay, Article 144. Next question. What is the purpose of Article 143 in the Indian Constitution? In the previous questions, we have already seen under Article 143, the President can seek the Supreme Court's advice in certain matters related to the public importance. Okay, that is why it is important. The answer is see, the President of India can consult the Supreme Court on important legal and public interest issues. Under Article 143, it is advisory jurisdiction of the Supreme Court. The next question. Is the Supreme Court's opinion under Article 143 is binding on the President or not? This is the question. The answer is the Supreme Court's opinion is advisory in nature and it is not legally binding, because see, under Article 143, the President seeks the advice of the Supreme Court. It is just advisory in nature, so it is not legally binding. The President may or may not follow the advice of the Supreme Court. Can the President refer any question to the Supreme Court under Article 143 or not? Just now we have seen under Article 143 the President seeks advice of the Supreme Court. Now the question is, can he refer any question to the Supreme Court or not? See, the President can only refer questions that are of significant public importance, or the question involves legal issues that require constitutional interpretation. Only then the President can refer the question to the Supreme Court. See it again. The President can only refer questions that are of significant public importance or that involve legal issues that require the constitutional interpretation. Next question. What is Article 142 of the Indian Constitution? Article 142 of the Indian Constitution, it empowers the Supreme Court to pass decrees or orders. The Supreme Court pass decrees or orders based on Article 142 of the Indian Constitution. The orders that are necessary to ensure complete justice in any matter before it. Okay. Next question. Can the powers under Article 142 override the Constitution or not? This is the question. Just now we have seen under Article 142 the Supreme Court pass decrees or orders. Okay. The answer is the Supreme Court cannot use Article 142 to contravene the constitutional provisions. Okay, whatever may be the Supreme Court's order, it should follow the constitutional provisions and they cannot contravene the constitutional provisions. Next question. Are the powers under Article 142 unlimited? The answer is no. The powers given to the Supreme Court under Article 142 are not unlimited. Just now we have seen they must follow the constitutional provisions. See here, the orders given by the Supreme Court subject to the laws made by the Parliament. They must be based on the laws made by the Parliament and they must be exercised judiciously within the constitutional limits. So they are not unlimited. Next question. What is Article 141 of the Indian Constitution? The law declared by the Supreme Court is binding on all courts within the territory of the India. This is Article 141 of the Indian Constitution. See here, Article 141 says the law declared by the Supreme Court is binding on all courts within the territory of the India. The next one. What is the significance of Article 140 of the Indian Constitution? Article 140 empowers the Supreme Court to exercise ancillary powers to fulfill the constitutional duties more effectively. See this again. Article 140 of the Indian Constitution says it empowers the Supreme Court to exercise the ancillary powers to fulfill the constitutional duties more effectively. What do you mean by ancillary powers? Ancillary powers are supplemental to the primary powers. Next question. Who has the authority to confer additional powers upon the Supreme Court under Article 140? Just now we have seen under Article 140 Supreme Court uses its ancillary powers. Okay. Now this question is asking who has the authority to confer additional powers upon the Supreme Court under Article 140? The answer is nothing but the Parliament. See, the Parliament has the authority to confer additional powers upon the Supreme Court under Article 140. Next question. What is Article 139 of the Indian Constitution? Before going to this question, let us see Article 32. See, under Article 32, the Supreme Court can issue writs for the enforcement of the fundamental rights. Now, let us see this question. What is Article 139 of the Indian Constitution? Article 139 empowers the Parliament to confer additional powers on the Supreme Court. Why? To issue writs for the purpose beyond enforcing the fundamental rights. See, the Parliament can confer the additional rights upon the Supreme Court to issue writs for the purposes beyond enforcing the fundamental rights, because for enforcing the fundamental rights Supreme Court can issue writs under Article 32, but for the purposes beyond enforcing the fundamental rights the Supreme Court can issue writs, and that power given by the Parliament under Article 139 of the Indian Constitution. Okay, see this again. Under Article 139 of the Indian Constitution, Parliament can confer additional powers upon the Supreme Court. Why? To issue writs for the purposes beyond enforcing the fundamental rights. Next question. How is Article 139 different from Article 32? See, under Article 32, Supreme Court can issue writs for the enforcement of fundamental rights. See, under Article 139, Supreme Court can issue writs for the enforcement of rights other than fundamental rights, because for enforcement of fundamental rights, Supreme Court already has the Article 32. For the enforcement of rights other than fundamental rights, the Supreme Court uses Article 139, and Parliament has the power to confer those powers to Supreme Court. Next question. See, Article 132 deals with the issuance of writs for the enforcement of the fundamental rights, whereas Article 139 allows the Supreme Court to issue writs for broader legal purposes other than enforcement of fundamental rights. Next question. What is Article 138? Article 138 allows the Parliament to enlarge the jurisdiction of the Supreme Court over the matters in the Union List. Okay. Already the Supreme Court is already having the jurisdiction in the matters of the Union List. Okay. To enlarge this jurisdiction, the Parliament has the authority under Article 138. Next question. Can the jurisdiction of the Supreme Court be expanded without Parliament's approval? Just now we have seen under Article 138, Parliament has the power to enlarge the jurisdiction of the Supreme Court over the matters of the Union List. Okay. Now this question is asking, can the jurisdiction of the Supreme Court be expanded without Parliament's approval? So the answer is no. See. Any expansion of the jurisdiction of the Supreme Court under Article 138 must be approved by the Parliament through a law. Okay. Next question. How does Article 138 affect the central state government cooperation? Article 138 allows the central state governments to work together by granting Supreme Court additional jurisdiction through agreements. See this again. How does Article 138 affect the central state government cooperation? Article 138 allows the central state governments to work together by granting Supreme Court additional jurisdiction through agreements. Okay, next question. What is Article 137 of the Indian Constitution? Article 137 enables the Supreme Court to review its own judgments or orders to ensure justice and rectify errors. See, we have already seen Article 137 is nothing but the review jurisdiction. Okay, review jurisdiction of the Supreme Court. So thus under Article 137, the Supreme Court can review its own judgment or order. Why? To ensure justice and rectify errors. Okay, under Article 137, Supreme Court has review jurisdiction. It can review its own judgments or orders. Next question. What is Article 136 of the Indian Constitution? The answer is Article 136 allows the Supreme Court to hear appeals in special cases, even when regular appeal routes are not available. See here. When regular appeal routes are not available, the Supreme Court to hear appeals in special cases. This is nothing but a special leave petition. So the special leave petition is the power given to the Supreme Court exclusively under Article 136 of the Indian Constitution. Next question. What is the purpose of Article 133? The answer is Article 133 grants the Supreme Court the appellate jurisdiction in civil matters. Okay, Under Article 133, the Supreme Court has appellate jurisdiction in the civil matters, allowing it to hear appeals from the high courts if certain conditions are met. So, in brief, under Article 133, the Supreme Court has appellate jurisdiction in civil matters. Next question. What role does the High Court play under Article 133? Just now we have seen under Article 133, Supreme Court has appellate jurisdiction in the civil matters. Okay, in the civil matters. What role does the High Court play under Article 133? This is the question now. Okay. Let's see the answer. The High Court is responsible for certifying that a case involves significant legal questions that need to be decided by the Supreme Court. That means the High Court certifies that this case is involving a significant legal question that needs to be decided by the Supreme Court. Then the case comes to the Supreme Court, and Supreme Court has appellate jurisdiction over the civil matter under Article 133. When can an appeal be made to the Supreme Court under Article 133? Just now we have seen two questions regarding Article 133. Under Article 133, Supreme Court has applied jurisdiction over the civil matters, and it is the High Court that certifies. Okay. So now this question is asking about, when can an appeal be made to the Supreme Court under Article 133? The answer is, an appeal to the Supreme Court can be made if the High Court certifies that, if only the High Court certifies that the case involves substantial question of law, and that requires the intervention of the Supreme Court. That means the High Court certifies that the case involves the substantial questions of law, and the High Court says it requires the intervention of the Supreme Court. Only then the appeal can be made to the Supreme Court under Article 133, and that is in the civil matter. Okay, civil matter. Next question. What is meant by substantial question of law under Article 133? Just now we have seen under Article 133, High Court certifies that the case is involved a substantial question of law. Now, what is it meant by the substantial question of law? This is the question. Let's see the answer. A substantial question of law refers to a legal issue that is significant and has broader implications, affecting not just the parties in the case but also the interpretation of the law or constitution itself. That means a substantial question of law refers to, it is a legal issue that is significant and has broader implications, and the legal issue that is not just affecting the parties in the case but also needed the interpretation of the law or the constitution itself. Then it comes under the substantial question of law. Then the High Court certifies and Supreme Court takes the appeal. Okay, next question. What is Article 134 of the Indian Constitution? Article 134 grants the Supreme Court appellate jurisdiction in criminal cases. Just now we have seen under Article 133, Supreme Court has appellate jurisdiction over civil cases. Under Article 134, Supreme Court has appellate jurisdiction over criminal cases. Okay, criminal cases, and it allows the Supreme Court to review judgments, orders, or sentences passed by the High Courts. Next question. When can an appeal be made to the Supreme Court under Article 134? Okay, under Article 134, an appeal can be made to the Supreme Court in criminal cases. Under Article 133, it is about civil cases. Okay, this is for 134 is for criminal cases, 133 is for civil cases. The question is, when can an appeal be made to the Supreme Court in under Article 134? Suppose, see the answer is, if the High Court reverses an acquittal, or if the High Court sentences the accused to a death sentence, or if the High Court withdraws a case for trial before itself and convicts the accused sentenced to death, or if the High Court certifies the case as a fit for appeal under Article 134. In such cases, the appeal can be made to the Supreme Court in criminal cases under Article 134. Next question. How does Article 135 ensure the continuity in the judiciary? We are talking about Article 135. Article 135 enables the Supreme Court to inherit the authority of the federal court. Okay, the Supreme Court will inherit the authority of the federal court under Article 135. Okay, next question. What is the role of the federal court under Article 135? The federal court, which served as the highest judicial authority in the British India, and it transferred its jurisdiction and powers to the Supreme Court in relevant cases. Okay, see here. The federal court is the court which served as the highest judicial authority in the British India. Okay, under Article 135, the federal court transferred its jurisdiction and powers to the Supreme Court in relevant cases. Okay, it is under Article 135. Next question. What is Article 135 of the Indian Constitution? Article 135 defines the jurisdiction and powers of the Supreme Court over the matters that are not covered under Article 133 and 134. So, see here 133, 134, 135. All are dealing with the appellate jurisdiction of the Supreme Court. 133 is for civil cases, 134 is for criminal cases, and if at all we are missing any point in the 133 and 134, they come under 135. That is what Article 135 is saying. Okay, let us see this again. Article 135 defines the jurisdiction and powers of the Supreme Court over the matters not covered under Article 133 and 134. And if such jurisdiction and powers were exercisable by the federal court before the commencement of the Constitution. Okay, before the commencement of the Constitution, we have the federal court, and federal court transferred its jurisdiction to the Supreme Court under Article 135 of the Indian Constitution. Okay, next question. What is the purpose of Article 132 of the Indian Constitution? Article 132 empowers the Supreme Court appellate jurisdiction in cases involving substantial question of law. Okay, the Supreme Court, see here, the Supreme Court having appellate jurisdiction in cases involving substantial questions of law. We have already seen what the substantial questions of law means. Okay, so the Supreme Court have appellate jurisdiction in cases involving substantial questions of law. It is under Article 132. The next question. Is the High Court certification mandatory for the appeal under Article 132? The answer is a certification from the High Court is mandatory to confirm that the case involves a significant constitutional question. In the previous questions, we have already seen the High Court should certify that the case involves significant constitutional questions or significant question of law. In such cases, the High Court certification is mandatory for appeals under Article 132 also. In the before question, under Article 132, we have seen the appellate jurisdiction of the Supreme Court in the matters involving the substantial questions of law. Okay, next question. What is the purpose of Article 131? The answer is Article 131 empowers the Supreme Court original jurisdiction in disputes between the central government and state governments or among the states. See here, the original jurisdiction of the Supreme Court is nothing but a cases between the central government and state government or state government and state government. Okay, the cases involving the disputes between central government and state government or state government and state government. Such cases will come under the original jurisdiction of the Supreme Court under Article 131 of the Indian Constitution. Now let us see the jurisdictions of the Supreme Courts again. Under Article 131, it is the original jurisdiction. Okay, 132, 133, 134, 135. These come under appellate jurisdiction of the Supreme Court. Under Article 137, the Supreme Court can review its own judgment, that is review jurisdiction. Okay, Under Article 143, the President can refer a matter to the Supreme Court for its advice. This comes under advisory jurisdiction of the Supreme Court. Okay. Article 131, original jurisdiction of the Supreme Court. 132, 3, 4 and 5 comes under appellate jurisdiction. Article 137 is review jurisdiction of the Supreme Court. And Article 143 of the Indian Constitution is nothing but the advisory jurisdiction of the Supreme Court. Next question. What is Article 130 of the Indian Constitution? Article 130 states that the Supreme Court shall sit in the Delhi. Supreme Court shall sit in the Delhi, or the Supreme Court shall sit at any other place as the Chief Justice of India may appoint. But for that, the approval of the President is needed. Okay. The Supreme Court usually sit at Delhi, but it can sit anywhere in the India other than Delhi. But that can be decided by the Chief Justice of India, but the prior approval of the President is needed. Okay, next question. What is Article 129 of the Indian Constitution? The answer is Article 129 of the Indian Constitution declares that the Supreme Court is a court of record. See here. Which court is the court of record? It is nothing but the Supreme Court. The Supreme Court is a court of record under the Article 139 of the Indian Constitution. Next question. What does it mean for the Supreme Court to be a court of record? This question is repeated, we have already seen, but let us see it again because it is very important. See, the Supreme Court is a court of record under Article 129. Now, what is the court of record? The Supreme Court judgments, orders and proceedings are permanently recorded and serve as a conclusive evidence in all courts and cannot be questioned. That means the Supreme Court judgments, orders and proceedings all are permanently recorded and saved. Okay. Thus, the Supreme Court is the court of record under Article 139 of the Indian Constitution. The next question. What is the purpose of Article 128 of the Indian Constitution? Article 128 of the Indian Constitution. Answer is Article 128 allows the retired judges of the Supreme Court or High Courts to sit as temporary judges in the Supreme Court. Okay. The retired judges of the Supreme Court or High Courts to sit as a temporary judges in the Supreme Court. That is allowed by the Article 128 of the Indian Constitution. Next question. Who has the authority to appoint an ad hoc judge under Article 127? Ad hoc judge means temporary judge. Okay. Under Article 127, the Supreme Court can have ad hoc judges or temporary judges. Now the question is about who has the authority to appoint those ad hoc judges. The answer is the Chief Justice of India can request the appointment of an ad hoc judge. But this requires the prior consent of the President. The prior consent of the President is required. The Chief Justice of India will appoint the ad hoc judge. Okay. That too, it can be done only when there is a lack of quorum. Quorum means the minimum number of judges that has to be present to conduct the business of the Supreme Court. Okay. That is the quorum. If there is a lack of quorum, then only the temporary judges or ad hoc judges can be appointed. That too, prior consent of the President is required. And the judge who is going to be appointed as an ad hoc judge of the Supreme Court must be eligible for the appointment as a Supreme Court judge. That means he should be a citizen of India and he has 5 years of experience as a judge of the High Court or 10 years of experience as an advocate in the High Court. Okay. Then only that person can be appointed as an ad hoc judge under Article 127 of the Indian Constitution. Next question. What is Article 126 of the Indian Constitution? Article 126 deals with the Acting Chief Justice of the India, ACJ, Acting Chief Justice of India. In the absence of the Chief Justice of India, or if the place is vacant, then Acting Chief Justice of India can be appointed under Article 126 of the Indian Constitution, and the President will appoint that Acting Chief Justice of India. Let us see the answer again. See, Article 126 of the Indian Constitution provides for the appointment of an acting Chief Justice of India when the office of CJI is vacant or when the Chief Justice of India is unable to perform their duties due to the absence or other reasons. Okay, the President of India appoints the acting Chief Justice of the India. Next question. What is Article 125 of the Indian Constitution? The answer is Article 125 deals with the salaries, allowances and other benefits of the Supreme Court judges. Okay, the salaries, allowances and other benefits of the Supreme Court judges are dealt by the Article 125 of the Indian Constitution. Next question. Who determines the salaries and allowances of the judges under Article 125? Supreme Court judges. Okay, the salaries and allowances of the Supreme Court judges are determined under Article 125 by the Parliament of India. Okay, the Parliament has the authority to determine the salaries, allowances and other benefits of the judges, Supreme Court judges, through legislation. That means they pass a law and they will provide all these salaries and allowances. Next question. What does Article 124 of the Indian Constitution deal with? The answer is Article 124 provides for the establishment and constitution of the Indian Supreme Court, including the appointment, qualifications and removal of the Supreme Court judges. That means the appointment and the qualification of the Supreme Court judges and removal of Supreme Court judges are dealt by the Article 124. Also, the establishment and constitution of the Supreme Court is also mentioned under Article 124 of the Indian Constitution. The next question. How are Supreme Court judges appointed under Article 124? The answer is the Supreme Court judges are appointed by the President of India in consultation with the Chief Justice of India and other senior judges. This is nothing but the collegium we have already seen. Chief Justice of India plus 4 other senior judges will constitute collegium, and upon the recommendations of the collegium, the President of India will appoint the Supreme Court judges. The next question. What are the qualifications required for being appointed as the Supreme Court judges? We have already seen he must be a citizen of India and 5 years of experience as a High Court judge or 10 years experience as an advocate in the High Court. See this. He must be a person of citizen of India, have served as a High Court judge for at least 5 years and have been an advocate in High Court for at least 10 years, and he has to be recognized as a distinguished jurist in the opinion of the President. The next question. What is the tenure of the Supreme Court judge under Article 124? The answer is a Supreme Court judge holds office until the age of 65 years. There is no specific tenure, but the Supreme Court judge can hold the office until the age of 65 years. Okay, 65 years. So friends, with this I conclude this session. Thanks for watching my video. If you like the video, please click on like button and share it to your friends and family members who are preparing for competitive exams. And please click on subscribe button for more such videos. Thank you.